Well, we are about to start some landlord, tenant, and civil matters. We have quite a full docket this afternoon, and the lawyer should be checking in here shortly. We'll get ready to turn everything on. See how we do today.
Afternoon.
Good afternoon. We start with a couple of termination of tenancy cases. And then we've got a non-payment of rent on Bell. And that one is, he's not going to show up. He's already gone. But both of these termination of tenancy people probably need some help. I'll bring in Mr. Barnes.
Cool.
We are live. Good afternoon, John.
Good afternoon.
Just for your info, Mr. Irwin pled to the DWLS charge.
Okay.
So you can close that file out. He
Good.
got sentenced on his other charges. He's going to be in jail for a while yet on some of the other stuff. Your client is in the waiting room. No sign of the defendant yet. Bettina's here with us. Then we've got another one, and then you've got Busher also, don't you?
Yeah, and she's here waiting at my office in the lobby. She doesn't have a Zoom thing, so she's just going to sit here in my office with me during the hearing. So if you need input from her, she'll be here.
All right, that's helpful.
I just told her as long as she wears a mask and stays 6 feet away, she's fine.
We had a session at the judicial conference last week about COVID, the current status of COVID in the courts, and their position was if you had 2 of something, you were probably all right. For example, if you had a vaccine and you were outside, you're all right. Vaccine and a mask, you're all right. If you're a vaccine and short duration, you're all right. So we'll see how we're doing. Now Tammy is here. So I'm going to bring S&L Properties in.
Just to catch up, I think, Your Honor, that we did submit proposed judgments on the 2 that I had today last week.
Yes. Why don't you go ahead and bring Miss Busher in, and we've got the defendant. We could start that one while we wait and see whether Miss Ewers appears.
All right.
Good afternoon, Miss Abel. Can you hear me?
On that other one that I have it was scheduled first, the defendant's not here yet. So if he's got somebody on your case, then we can go ahead, he'll leapfrog and do yours.
Miss Abel, can you hear me? Tammy, can you hear me? Our continued struggle. All right, Miss Abel, can you hear me? You need to unmute your mic. We don't have a very good signal from out there on Coon Hollow Road.
Should be pretty good service. We have fiber optic cable now through Midwest Energy Co-op, Your Honor. It's fantastic service.
Well, maybe it's on Spence Road, but I don't know whether it's at Miss Busher's place there on Coon Hollow. Tammy, can you hear me? This is always a struggle.
What do you have for Bill?
I don't know who she is. I think it's Midwest.
Midwest Electric? Okay, yeah.
John, I don't have a phone number for Ms. Fosdick, Ms. Abel. If you've got one, would you email it to me? Tammy, I'm going to ask you to unmute your mic. Can you hear me?
Your Honor, phone number we have is 269.
No. Email it to me. I don't want to put it out over
Oh,
there.
okay, all right.
Tammy, can you hear me? Her screen appears to be frozen, and when I get that number, I'm going to hang up and call her on the phone. Hasn't come through yet.
I just sent you the email with the phone number, Your Honor.
Wait for it to go through. There it is. Oh, there it is. All right, I'm going to hang up on her and call her. Ms. Fosdick, can you hear me? Now we have Steve. I'm not sure who he is. Oh, it's Steve Brown. He's a little early. Good afternoon.
I'm early.
You're all right. You can watch our proceedings. Welcome back.
Well, it's good to be back, Judge.
Has been forwarded to an automated voice messaging system. 26953543449 is not available. At the tone, please record your message. When you've finished recording, you may hang up or press 1 for more options.
Ms. Abel, this is Judge Middleton attempting to call you for our landlord-tenant proceeding. We weren't able to connect. with your signal, so I'm trying to reach you by telephone. So please answer the phone. Let's see who this is. We've just squandered about 8 minutes doing nothing but chasing our tails. I've got a phone number in the feed now. Who am I speaking with?
Tammy.
All right, Tammy. I tried to call a number, but that apparently wasn't correct. I've known you under a couple names, Tammy Fosdick, but you go by Abel now?
Yes.
All right. This is Judge Middleton. I'm here at the courthouse. John Barnes is here, and your landlord, Miss Busher, is also here. They're asking to terminate your tenancy and have you move. So I read to tell you what your rights are as a tenant in a landlord-tenant proceeding. Can you hear me?
Yes, I can.
All right. As a defendant in a landlord-tenant proceeding, including a termination of tenancy, you have the following legal rights. You have the right to obtain counsel for representation in this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you. You have a right to a trial by a jury or by the court. If the action is for non-payment of rent, which this isn't, Keystone could be available to help you.
Okay.
You do not need a judgment. The summons and complaint are sufficient to get
What is the
assistance.
reasoning for?
Well, just a minute. Let me finish this, and then we'll talk about that. If the plaintiff is agreeable, a citizen mediation services may be available as a possible source of case resolution. If both parties are agreeable to mediation, the court can set that up. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment will be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. So this is a termination of tenancy. You have a month-to-month tenancy. You had a lease, but it's expired, and now it's month-to-month. And your landlord served a notice to quit, asking that you move, I think by April 2nd. You have not moved, so they followed the next step of asking to terminate the tenancy. Is that correct, Mr. Barnes?
Yes, Your Honor. And we are not asking for a money judgment. We simply want judgment for possession based on the termination of tenancy.
What's your position, Ms. Abel?
So, why is there a termination of tenancy for one thing?
Well,
I've been a
they
good
don't-
tenant.
Well, they don't have to give a reason.
Okay.
The lease is expired, it's month to month. They can say, well, I want my niece to move in here. I want to tear down the building and put up a parking lot. I want to get this apartment empty so I can refurbish it.
Okay.
They can do it for no reason. They can't do it for a bad reason. They're not alleging that you're a bad tenant. They haven't filed that you violated the lease. It's simply when the lease is up and it's month to month, they can ask to terminate it. Now,
so
go
as
ahead.
a tenant right now, I have looked since I first got in the paperwork, and there is nothing available to rent right now in St. Joe County. I can't even find a storage unit to put my stuff into. So I'm kind of in a bind.
Miss
at the
Abel,
beginning
I'm not going to do this today. And I hear this story. It's not a story, it's a reality. I hear it every week. There's not
Yeah,
enough
I can
affordable
imagine.
housing to move to. And every week people would tell me I would move if I had some place to move to.
Exactly.
But that's not a defense necessarily. The law requires that I set this for a second hearing to give you an opportunity to get some legal help.
Okay.
So let's see where we move this to. Now, if they get what they asked for, on the next date, you would have 10 days to move.
Only
And
10?
Yes.
I thought there was a, I'm sorry. I thought there was a CDC moratorium where I wouldn't have to be out until June the 30th.
There is if it's for non-payment of rent. They're not alleging
Yeah,
that
but
you're on rent. They're just asking to terminate your tenancy. So
Okay.
today is the 10th. Let's see. Have to set it for at least 7 days away. Oh,
So do I have that legal right since it's not for payment to stay until June 30th?
no, you don't. Just a minute, I got screwed up here. Today's the 10th. I have to. If it's for non-payment of rent, I have to set it out 30 days from now, and you have the right to ask for the moratorium. This is not a non-payment of rent case, it's a termination of tenancy case. And,
Right. It won't, the first paper I received was for back rent. And they changed it
now let's take a look.
because I offered to pay.
The notice to quit I've got just is termination of tenancy.
Okay.
John, are you, and Tammy, I'm not making light of this. People have a hard time finding a place to go. And every time I move somebody up, there's somebody waiting to move in. I don't know why she wants you to move out. I guess to some extent I don't need to know. If it's for an improper reason, then you could ask for some help. John, are you available next Monday, May 17th at 2 o'clock?
I believe so. Let me check quickly here. Yes. Monday,
All
May
right.
17 at 2.
Miss Abel, are you available at that time? Tammy? Can you hear me? Well, that's 7 days, and we have to allow at least 7 days on a termination of tenancy case. So I'm going to continue it to May 17th at 2 p.m. We lost her. She may come back in. It's a tough situation. Her rent is quite low. I think Ms. Busher's been subsidizing her for some time. And I don't know or need to know the reason for terminating the tenancy. The lease has expired. And these are the most difficult types of cases when the tenant isn't necessarily violating the lease, but the lease time period is up and they're not eligible for the stay. So we'll address this further next Monday at 2 o'clock. Now, Mr. Barnes, your other case was set for 1:15, and we did this one first. No one has appeared on that case. Let me call it. I believe this is Ms. Corpening in the waiting room.
Can
This
I
is filed-
excuse, Your Honor,
No,
can I
no.
excuse Ms. Busher then?
Yes.
Okay. You're excused then. Thanks, Gail. I'll see you here next Tuesday, just shortly before 2 o'clock, okay?
Next
All right,
Monday, John.
I'm sorry,
Monday.
next Monday, May 17 at 2 p.m. here. Thank you. Excuse me for not seeing you to the door.
All right, this matter is entitled SL Property Solutions LLC versus Patrice Ewers and any other occupants at 126 North Main, Apartment 8. This defendant was personally served. There is no lease that I have a copy of. The notice to quit was March 24th or April 2nd. Was this a week-to-week tenancy?
Yes.
All right, now let me see who I've got here. I got a.
Okay.
Good afternoon. Who am I speaking with?
This is Terry Richmond.
Who?
Terry Richmond. Terry Richmond.
No, it's not.
Okay. Is this the Zoom meeting for the hearing for Burgess versus Richmond?
Correct.
Or Richmond versus Burgess? Andy Rognus is the attorney?
Yes. What's your name?
Terry, Terry, Richman, Richman.
You're not Terry Richmond.
Okay, who then am I?
I don't know, but I'm going to remove you from the session. Andy, you have to tell Terry Richmond someone's impersonating her.
Actually, that's the other Terry Richmond. It's Larry's brother, Terry.
Oh, it is?
Yeah, there's Larry, Gary, and Terry.
Well, how's he involved in it?
He owns property on Boone Road.
Oh, it is Terry Richmond. I'm sorry. I kicked the guy out.
Big Lebowski. The other Terry Richmond.
The other Chuck Lebowski. I'm sorry. See if you can get your client back. Is this Tammy again?
Yes.
All right, Tammy, I continued your matter until next Monday at 2 p.m. I suggest you try to get a hold of legal aid or other assistance or prepare to move. I'd also suggest perhaps you contact Keystone Place, see if they can help you find some housing. Have you been in contact with them?
No, because I am able to pay my rent. I don't need help with that. And with my health issues, I have severe asthma and I had COVID and I can't get my vaccine until the 21st because you have to wait 2 months.
Yes.
And so I stay pretty much in the house. I can't go where there's a bunch of people.
All right, well, you won't have to come here. This wasn't my
no, but I'm talking
reasons
about
I don't understand. Your landlord is moving to evict you. So I strongly suggest you either get a hold of Keystone to see if they can help you find a place, or
Okay.
Be present next Monday at 2 o'clock.
Okay.
Okay, I'll see you then.
All right. If I can't get on the computer, I'll call again like I did.
Okay, thank you.
Thank you, Judge.
Okay. Now, I kicked off a legitimate defendant or a plaintiff, and if Andy can get him back in there.
Yeah, he's
But anyway,
back in.
let's address the case we were trying to address. I've got it. I'll leave that guy there. This is S&L Property Solutions versus, as I said, Patrice Ewers. It was a week-to-week tenancy. There appears to be no lease. The defendant was personally served and is subject to default. Is the defendant still there, the tenant still there?
As far as we know, yes.
Mr. Barnes, what's your position here?
We'd just like a default entered, Your Honor.
Which building is this, what is this on top of? What's the Main Street, first floor property?
It's across the street from Little Caesars, Your Honor.
Oh, you bought that building? Okay, 303, that's 126, okay. You doing week-to-week tenancies in that building?
Yes.
Okay, well, she isn't here, or he isn't here. Subject to default, plaintiff has a right to possession on or after May 20th. No money judgment is entered at this time. All right, John, that finishes our business. We'll
Thank
have
you.
a difficult date next week with Miss.
Yeah, hopefully she can talk to somebody at Keystone and get something lined up.
Well, it isn't like they just wave their magic wand and find them a place, but perhaps they could provide some assistance.
Well, I think they're doing a good job with what they've got to work with, Your Honor. Good clearinghouse for information. Anyway,
All right.
thank you.
All right, thank you.
Thank you.
All right, Mr. Richmond,
Yes.
my apologies. I thought you were Terry, T-E-R-R-I Richmond, who I've known for many years, and it wasn't
Yeah,
her
that's my
voice. And I
sister.
don't know if it was some imposter. Anyway, you're Terry, T-E-R-R-Y Richmond.
Yeah,
And
Terry
your tenant-
T-E-R-R. She is my sister-in-law.
All right, I got it straight now. My apologies. I owe an apology. Jessica Burgess is here. Mr. Andrew Rognes is here. This is filed as a non-payment of rent case. And so, Ms. Burgess, I need to advise you of your rights. As a defendant, can you hear me? You need to unmute.
I can
your
hear
mic.
you, yes.
All right.
Okay. Can you hear me
All
now?
right. Yes, I can. All right,
Okay,
Ms.
sorry.
You have the right to obtain counsel for representation in this matter. You're here as a tenant in a non-payment of rent case. If you cannot afford an attorney, a legal aid attorney may be available to help you. We gave you that information. You have the right to a trial by a jury or by the court. If the action is for non-payment of rent, which this is, the Michigan Department of Health and Human Services in our county, that's Keystone Place, or other federal or state agency may be able to assist you with payment of some or all of the rent. Defendants do not need a judgment to receive assistance from Keystone. The summons and complaint from the court are sufficient. If the plaintiff is agreeable, the Citizens and Mediation Service, Inc. may be available as a possible source of case resolution. If the parties are interested, the court can facilitate that. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you will waive the rights listed above but have the following additional rights. The judgment may not be enforced until 3 business days have passed. You may move to set aside this judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. However, if the judge does not find in your favor, the original judgment would stand. This is filed as a demand for non-payment of rent. Bettina Emery from Keystone Place is here on the feed, and Keystone is the agency that could be available to provide some emergency housing assistance. This is a property out on Boone Road, and the rent is quite substantially in arrears. Mr. Rognes, what's the current arrearage?
Your Honor, my understanding is that it's $4,350 that was through April 12th. The rent's due on the 15th of each month, so you now got April. And my supposition is that with the statutory adjournment, we'll probably be back into May. So I thought emailed over a breakdown to the court.
You did. You got through May, 5,650, if we include
Yeah,
April and May.
That's through May 15.
All right, plus costs.
Correct.
Mr. Or Miss Burgess, have you been in contact with Keystone?
Yes, I have.
Bettina, what can you tell us about this one?
I just heard from Mrs. Burgess today, and she was filling me in on the details of the non-payment of rent, and we may not be able to help her.
So you don't know yet?
I do not know yet.
In March, the Supreme Court changed the rules once again and requires that I set this for a second hearing 30 days out from today. So, Mr. Richmond, I don't have any discretion in that matter. Let's find a date that works for Andrew.
And Your Honor, can we get an escrow order in between now and then too?
No, it doesn't allow that. It simply says she's
Mr.
subject to a,
Middleton?
just a minute.
Okay.
That would take us to June 14th at 1:15.
I've got something with Rob at 1:15, but I can bounce back between you two.
Well, how about if I set it, how about we set it at 2?
That'd be even better.
All right, Miss Burgess, is your husband there with you?
No, he is not.
Is he still there?
Yes, he is taking care of our children right now so that I can do the court.
What did you want to tell me?
Now there are other people that are on the property. It's actually my husband's baby mama. They have been harassing me. They have been putting me through hell, excuse my language. I have talked to lawyers. They have advised me that I need to ask my landlord if he could go ahead and evict them, because he would have to evict them from the property to get their pop-up camper off the property.
So there's
they keep telling me that they're going to get it off the property. Just Friday, they said that they were going to get a truck and rent and get it off the property. And then the next day, they said that I have court on Monday, that they don't need to do anything, that it's their property. They are putting me through hell. I just need them off my property. I don't need to deal with them.
Mr. Richmond, what can you tell me about that you're renting a property?
Okay, Your Honor, this morning is the very first I've heard of this. Now, she doesn't have a place to live there. The house burned. And it's been destroyed, and I need to clean it up. They're holding all of these funds in escrow because I can't clean it up.
So the Burgesses are living in this house?
No, we are not.
I don't think they should not be.
All right.
We are not living in the home. I don't know where. We have our belongings that are on the property. I mean, that was our home. I would like to try to purchase the property, but my co-signer that I have that's willing to co-sign for me will not co-sign for me until their pop-up campers off the property, because they're just harassing me. And,
all right, well, he doesn't wish to sell you the home. So I'm not going to make her pay rent for a burned out house. When was the fire?
Exactly, but I just want her gone. It's what I want, so I can clean up the property.
All right, stop for a minute. When was the fire, Miss Burgess?
February 23rd.
Andy, this sounds like it should have been a termination of tenancy case.
Yeah, except that we would have had to have waited 3 weeks longer on the 30 days for the termination notice.
Well, I'm not going to order her to pay rent on a burned out property she's not living in.
She was delinquent from the last payment. All of this payment was from July last time she was current, that was paid on 11/6, but she was only current back to July 31st. Her payment is $150 a week.
Paid up on rent. My
All
husband.
right, just a minute, just a minute,
Okay,
just a
sorry.
minute. Mr. Richmond, you haven't appeared here before, but that ain't how it works. You're by telephone, I can't see you, you can't just blurt
Exactly.
something out. We're not
I'm
at
sorry.
the kitchen, we're in a courtroom. You have an attorney also that's here to represent you. So, Miss Burgess, you've got your property in a burned out house and he wants you to get your stuff out of the house. They filed it, in my mind, incorrectly as a non-payment of rent case. I'm not gonna make you pay rent after the house burned up. You need to get your stuff out of there, is what it boils down to. Have you made any provision to move anything?
Yes, I have been moving stuff. And I've talked to Terry, and he has said that he would sell me the property. Now, I have a co-signer that would help me so that I could get the money to obtain the property from Terry. But my co-signer will not help me out until these people are off the property, because all they are doing are harassing me. And I've talked to lawyers, and they have told me that Terry has to evict them from the property.
All right, that may be true. So, Mr. Richmond, how did these people come to put a camper up on this property you've leased to somebody else?
Like I say, Your Honor, this morning is the very first I heard of it. I got a text message from her telling me this. I've never heard of this before from her until today.
All right, Mr. Rognus?
I thought she said that it was her husband's baby mama living in the trailer or camper.
Yes.
So, I mean, that's really somebody associated with that. My suggestion would be she could just consent to entry of an order of possession and we can get those people out of there in 10 days. They're squatters. She doesn't have anything out to the place that she presumably couldn't move in the next 10 days, Ms. Burgess?
I couldn't. I want to buy the property.
Well, I understand.
All right, if this was filed as a termination of tenancy, Andy, I would only have to set it for 7 days. It was filed as a non-payment of rent case, so I have to set it out 30 days. But I'm not gonna order she pay rent for a burned out property that somebody else is living in. Now, Miss Burgess, how did these people come to put this camper on this property? Did your husband give her permission to put it there?
Well, they were only supposed to stay for like a week or two. And she came, my life's been a living hell. Okay, I have all the electric bills.
So your landlord did put them there with permission.
$5,000.
All right, well.
They are harassing me to this day, and
then,
they need to be gone.
Well, your landlord didn't let him move in there, you guys did. He doesn't even know about it. He needs to get him out of there, to be sure. But I don't know whether he wants to sell you this property or not. But it's filed as a demand for non-payment of rent. I have to set it for 30 days from today, which would be June
14th at 2 o'clock.
June 14th at 2 o'clock. I don't have any discretion in that matter. My suggestion is you get your stuff out of there. I'm not going to issue an escrow order, and I'm not going to make you pay rent for a property that's burned up. But I don't know whether he's going to sell you this property or not. If he does, well, then you can work out some deal between now and June 14th. But you let these people on there. He didn't. And so.
And they will not leave. They will not leave.
All right. Well, you didn't have the authority to bring them in there, and you don't have the authority to get them out. So you've created a giant headache for your landlord. At any rate, you have the right to, I understand, Bettina, why they won't be eligible for any assistance. You're not going to pay rent for a burned out house.
I'll pay to evict them. If my landlord evicts them, I will pay the cost for it.
That's between you and him. This matter is continued to June 14th at 2 p.m. and I'll take 2 Tylenol an hour before that hearing. All right, you're free to go.
Thank you, sir.
Thank you, Middleton.
Okay. Well, that's a humdinger. All right, I have a 145 hearing, but before I do that, I'm going to take care of Mr. Bush and Ms. Corpening, which is Memory Lanes versus Bell. File 21432LT. Let's see who this is. Galaxy S9. Is that you, Miss Holman? You're connecting to the audio, we hope. Mr. Brown kind of makes you want to get back in landlord-tenant cases, doesn't it? Probably not. Miss Galaxy S9, I'm still waiting for you to connect so we can talk. Chris, is that Mrs. Bell?
I really can't tell, Your Honor.
All right, Galaxy S9, we're getting close. Can you hear me? All right, now you need to unmute your mic. We're almost there. There we go. Can you hear me?
Yes, sir.
What's your name?
Heather Perez.
Which case are you here on?
I'm here to discover bank case.
Okay, we'll be there in a minute. All right, in the meantime, let's call Memory Lane Mobile Home Park versus Lee Bell and his wife. This is a property at Memory Lanes. Mr. Bell had previously received assistance. We learned on April 30th that Mr. Bell and his wife had moved to California, never to return, and we had to set it for a second hearing because we had service by attachment. At this point, Mr. Bush, it was filed as a non-payment of rent case. What's the arrearage?
Chris, do you know that right off the top of your head?
I had 4421 plus 280.
That is
It is
correct,
noticed.
Your Honor.
All right. 4421 plus 280 is John, you did give me a judgment. 4421 4701. The date for the writ, John will have to go with 10 days, but I'm going to put if defendant has vacated, plaintiff may take immediate possession.
Thank you.
Thank you.
The date for the writ is 5/20. Well, I've always known Mr. Bell as Hank, but apparently he's gone, and Wish him well. All right, John, I've signed that judgment. Ostensibly, the date for the writ and the appeal is May 20th, but I added, if defendant has vacated, plaintiff may have immediate possession.
Thank you, Judge. Thank you, Chris.
All right, thank you.
Thank you. Thank you.
Okay, now we're going to shift gears a little bit. We had a 145 motion, which is here. It's entitled Discover Bank. Back when we had real court, we would always set the civil motions at 145. Now with Zoom court, we're often backed up, which we are right now. This is entitled Discover Bank versus Heather Perez. It is a plaintiff's motion for summary disposition. Mr. Steve Brown is here on behalf of the plaintiff. Mr. Brown, could you unmute your mic? And Ms. Perez, would you? Mr. Brown, could you place your appearance on the record?
Your Honor, may please the court. I'm Attorney Stephen Brown. My bar number is 24389. I'm appearing for the purposes of the this hearing today. And had I been coming down to court, I would have brought my appearance with me, like I always have in the past.
Yes, the business of limited appearances pretty much dried up with the advent of Zoom court. The attorneys often come themselves. I've had very little substitute counsel in the last year. At any rate, welcome once again. This is a Buckles and Buckles case, and Mr. Brown would appear for them from time to time. Heather Perez is here. This is a claim for quite a bit of money. $9,436 plus cost is $9,584.21. This is a credit card from Discover Bank, and plaintiff filed an action and served it on the defendant. She filed a written answer, which we received on March 29th, explaining her circumstances and her current unfortunate financial situation and her inability to pay. She also forwarded a copy of that to Buckles and Buckles. Unfortunately, inability to pay is not a defense. So plaintiff filed what is called a motion for summary disposition, saying there is no material issue of fact and plaintiff has not stated a defense, so a judgment should enter for the plaintiff, and then the ability to collect on it may be a separate issue. Mr. Brown, is there anything else you wish to say about the motion?
Honor, you've stated it very accurately, and the answer is I do not have anything further to add.
Ms. Perez, summary disposition is a concept that lawyers use all the time. It's very unfamiliar to lay people, and so it's a bit of a foreign concept, but basically they say there isn't any issue and we should just get our judgment. You filed an answer which kept it from being a default, but what would you like to say about that at this point?
I understand I owe the money, sir. I'm not denying.
I'm having trouble hearing you.
I understand I owe the money, sir. I'm not denying the fact. I understand why they're seeking judgment.
All right, I'm going to enter the summary disposition.
Did Buckles and Buckles' office send you a judgment previously?
They did.
Okay. Ms. Perez, may I ask you a question? You're not in the military, are you?
No, sir.
Okay, thank you.
Ms. Perez, are you still out on Pulver Road?
Yes, sir.
All right. I'm gonna sign the order for summary disposition. $9,584.31. You do have 21 days to appeal that. And after 21 days, they can pursue collection. The name and address of the Buckles and Buckles Law Firm is on here. We're gonna send this to you at your house. I suggest you call them and see if you can set up some sort of installment payment plan. It's a lot of money, but if you don't have any money, you don't have any money. They can't collect money that you don't have, but the debt won't go away, and it will collect interest at 13%. So it's important to try to set up some sort of payment plan. All right, do you have any questions?
No, sir, not at this time, thank you.
All right, ma'am, you're free to go. All right, Mr. Brown, I'll see you again. I'll send that
Come
copy
back
out.
down to us. I look forward to coming back down to Centerville and crossing
They'll say they
line.
want to have lunch at Yoder's, so maybe sometime this summer. Let's be hopeful. Okay, you're good to go. Thank you.
Thank you, Judge. Have a wonderful day.
All right, now we've got two other landlord-tenant matters. We've got Salardo and Holman, which is set for 2. I'm surprised Ms. Holman isn't here. Then we've got River Trail versus Shelton. Mr. Salardo is here. Let's bring him in. Okay, this is file 21-415. It's entitled Ken Salardo versus Darlene Holman. Mr. Salardo's got the incongruous screen name of Bruiser Ken. I'm going to give him a proper name.
It's my pup's name.
Your pup's name?
My dog. Yeah, Bruiser.
Are you using his iPad?
No. I don't know why it comes up like that.
All right. Miss Holman is not here. I'm surprised by this, but let's talk about this case. This is file 21415LT. It is a non-payment of rent case. We made a calculation that rent was back on April 9th, $4,960 minus $1,850, $3,111 through April. Defendant indicated she had had no contact with Keystone Place. Bettina Emery is here from Keystone. She indicated she was withholding the rent, and she had a number of issues she wanted to raise. And I gave her an escrow order, and she was to pay escrow payments for April and May's rent to the court, which she has not done. She sent me an email dated May 7th indicating that she had a bunch of defenses that she wished to present, and she's not here. Ms. Emery, did you ever have any contact from this tenant?
No, Your Honor.
what happens is I end up making a record and then the people show up like 15 minutes late. Defendant has not paid escrow. I do not believe that there is a CDC declaration in here. Otherwise,
Your Honor, I did receive that from the court and sent it back.
no, a CDC declaration by the defendant.
Oh, okay.
Otherwise, we'd have to stay the eviction until June 30th. Yeah, she sent this email on May 7th. I will be attending this court date on May 10th. I have quite a bit of evidence as well as witnesses. And then she's not here. Well, let's calculate. What is the current arrearage according to you? I determined that through April it was $3,110, and the rent is $1,200 per month. So if we add May's rent,
Your Honor,
yes?
she had paid first and last when she signed the lease. So technically May is paid as well as December. So it'll be January, February, March, and April for $4,800 minus the $1,850 that she had paid.
That's how I came, all right, minus
Right.
1,850. 4,800 minus 1,850. 2,950. I'm not sure where I got the extra $110. Through May. The court costs, oh, I think we determined those were $160. No, there were late fees.
Yeah, the late fees were,
For
well,
160.
yeah, 4 months, right?
Which is $3,110.
Yeah, I think that's the same figure you came up with last time.
All right, now let's talk about our court costs. Filing fee of $46.16 from Sergeant Morse. And $130 filing fee. $176.16. $3,286.16 through May. I don't think I have a judgment. Let me look. I'll have the clerk prepare a judgment. But you're responsible for your own judgments, but I want to get this done. I'm going to ask you to stick around for just a minute. I have the other one's not till 2:45. All right, she's not here. I don't know why she's not here. She had indicated she was gonna be here and she's gonna present a bunch of defenses, although she didn't pay any of the escrow money. As far as you know, is she still there?
As far as I know, yes, sir. I even contacted her via text the end of last week, just saying if she would just leave, I would drop the case, and she just never even bothered responding to me.
Well, maybe she did. Maybe that's why she's not here.
I have a pretty good neighbor that lives next door, probably would have informed me if she left.
She has not filed for a CDC stay. If she does, even though she owes money, the eviction would be stayed until June 30th. She hasn't paid escrow, she hasn't filed for a CDC stay, and she isn't here. So I'm not sure what to say about that. Our next hearing isn't until 2:45, and that's a termination of tenancy. I'll let the clock tick here about 2 more minutes, and then I'll... Guadalupe, could you do a judgment for me in this case? I have a 2:45 and then a very busy small claims docket this afternoon with about 10 cases starting at 3 o'clock. I had blocked out some time for this because I thought it was going to take a while, but it doesn't take very long if she doesn't show up. All right, she has 10 days to move, which would be May 20th, or pay that amount. Maybe she took you up on your offer to simply vacate. Don't know, but she isn't here, and I'm not gonna just... Let's see here. She says... Make sure there's not any confusion here. Oh, I do have a judgment in here, Mr. Solardo. Guadalupe, I have a judgment in here that you probably already did for me. Yeah, it's clearly set for 2 o'clock. 3310 through May. Or 3110 plus 176.16. For a total of $3,286.16 by default. Date for the writ is 5/20. Today is May 10. If she does file for the CDC stay, I guess we'd be bound by it, but she has not. So, by default, I order she has until May 20th to pay $3,286.16, or she is subject to being evicted. If she dials in, I'll tell her she has 10 days to either appeal or move to set the default aside, but I don't know where she is or why she isn't here. All right, you're free to go, sir. Right, as soon as I disconnect you, she'll sign in. Tina, I don't think I need you at the 2:45 one. That's simply a termination of tenancy. You're welcome to click back in. All right, thank you.
Okay.
All right. You're good to go. Thanks for your help.
Yes, thank you, Your Honor.
And see what you can do of finding a whole bunch of affordable housing units we can have people move to, and they get evicted from where they are.
Yes, that would be So lovely.
That solved a lot of problems, wouldn't it?
It would. It would. All right. Thanks,
All
Your
right,
Honor.
thanks. All right, we're gonna let the feed run. Well, I'm gonna stop it. I don't know, we need to let it, well, I'll let it run for 27 minutes. We'll be back here at 2:45. Then we have a host of small claims matters starting right at 3 o'clock. idea. All right, we are back and preparing for our 3 o'clock case, or 2:45 case, excuse me. The defendant is here, plaintiff is not. Then we will take a short break and then go into our small claims cases. Good afternoon.
Good afternoon.
I'm going to put you in the waiting room. The plaintiff's attorney isn't here yet, but we'll be starting shortly. You're in the right spot. Oh, here he is now. All right, let's turn everything back on. All right, Ms. Shelton, Mr. Soltis is here with us now. And we are live on YouTube once again, and we're on the Zoom platform. We're recording this. This is entitled River Trail Apartments versus LaShonda Shelton. The file number is 21510LT. Ms. Shelton is present, and Mr. Soltis is present. We had a hearing last time. It was regarding the plaintiff's unwillingness to continue a month-to-month lease. And so we continued the matter for 10 days until today. Mr. Soltis, what's the situation here?
Well, Your Honor, first of all, is anybody from River Trail in your waiting room?
Not yet, no.
Okay. Well, this is a termination of tenancy after the expiration of a lease, and if Ms. Shelton has not moved out, we're asking for an order that she move out.
Ms. Shelton, we had talked about this before. You were planning at some point to leave, move to Texas, and get reestablished. It was just a matter of timing, which is why I guess there was nothing more than a month-to-month lease. What's your position?
I'm just gonna leave. I don't have time to deal with this.
All right.
River Trail doesn't want to get on the court hearing and say anything on why they can't give me a month-to-month lease. Neither can their attorney or whatever. So,
well, they don't want. You know, I guess they want to lease it on a longer term. Have you started packing stuff up?
Not quite. I know that I'm leaving though this week, so.
Okay. Do you know where you're going to?
I don't.
When you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. I don't believe I have a judgment here. Let me look.
No, Your Honor, I haven't sent it down yet.
All right. The law says you have 10 days from today to move or you're subject to being evicted. So 10 days from today is May 20th. May 20th is a Thursday. They don't have to evict you on May 20th. They have 56 days from today to ask for the writ of eviction. As I mentioned, there were several previous cases filed, and I'm not sure if that's why they didn't want to do a month-to-month tenancy. There were 3 cases that preceded this one. But we had the proper notice to quit. We had a 10-day continuance, and the defendant says she's going to move. And as long as you move by May 20th and turn in the keys, the matter will be over. If for some reason you can't move, you can ask the landlord to see if they'd be willing to give you an extension, say till Monday or something, but I didn't pull this figure out of a hat. The law says there's 10 days. Do you have any questions?
No.
All right. I'm going to send you this order. You do have 10 days to appeal it.
Your Honor, are you preparing the order, or do you want me to send?
No, I want you to email me one.
Okay, Your Honor, we've been having some trouble with our email simply and partially because my assistant Kim is gone for the week. Could we fax it to you?
Yeah, faxing is fine.
What is the fax number, please?
I don't remember it. Let's see if I have a card here. I'll email it to you.
Okay, very good.
All right,
I'll put that
thank
down
you.
this afternoon.
All right, Ms. Shelton, anything else you wish to say here?
No.
All right, you're free to go.
Thank you, Your Honor.
Good afternoon. Who am I speaking with?
This is Betty Callahan, property manager at River Trail Apartments.
You're late. We just finished the thing. Ms. Shelton agrees to move by May 20th, and we're going to do an order to that effect.
Okay.
You can contact Mr. Soltis. He was here. He asked if you were here, and you weren't, and so we just started. And I think you're a couple minutes later.
Yeah.
All right.
Late, but okay, May 20th, which is Thursday, week from Thursday. All right.
Okay.
Your Honor, and I do apologize for my being a couple moments late.
Okay, we try to start right on time. All right, thank you.
Thank you. Bye-bye.
Bye.
Hello?
Good afternoon. Who am I speaking with?
Mr. Bob Crandall.
All right.
Connor.
Mr. Crandall, let me give you a name. All right. Be with you at 3 o'clock, so you're in the right spot.
I'm going to try getting here as fast as I could.
Very good. I'll put you in the waiting room.